He set a trap on his fence. Look at my arm. I'm suing him for $45,000. That was what the HOA president of my neighborhood told the police. While her arm was still in a cast, she forgot one small detail. She climbed into my yard before dawn, uninvited, unauthorized, and she had no idea my camera recorded everything. I'm a software engineer, working remotely, living alone in Cedar Brook Heights for 8 months. I grow tulips to relax, not to cause trouble. I have a 6-foot fence. I have clear boundaries. But the entitlement of an HOA Karen who held power for 7 years made her blind. It all started when I woke up to the sound of wood groaning under the weight it was never meant to carry. A shadow was climbing over my fence. The noise pulled me from sleep before my mind could register what it was. A low creak, then a scrape, then the soft impact of feet on grass. I lay still, listening. Through the gap in my bedroom curtains, the sky was gray, the light thin and colorless. I pushed the fabric aside 1 inch. A woman stood in my backyard. She wore a floral dress, silver hair styled as if she had somewhere important to be. In her right hand was a small gardening trowel. Doris Whitmore. I recognized her from the HOA newsletters she signed with her full title beneath her name. She was looking around the yard with the careful attention of someone who knew she should not be seen. Her gaze swept past my vegetable garden, my tool shed, and stopped at the row of Queen of Night tulips I had planted along the back fence. Those tulips were rare, black petals with a purple sheen. I had ordered 20 bulbs from Holland, $700 total, and waited 3 months to see them bloom. Doris walked toward them without hesitation. She knelt, drove her trowel into the soil, and began digging. Something about the way she moved unsettled me. There was no fumbling, no pause to orient herself. She knew exactly where to dig, exactly how deep the bulbs were planted. It felt practiced, but I told myself I was imagining things. Maybe she had confused my yard for someone else's. Maybe she had some explanation I could not see from my window. I did not shout. I did not go outside. I watched. She placed 5 bulbs into a canvas bag, then stood and walked back toward the fence. She grabbed the top rail, pulled herself up, and swung one leg over. Her foot found a slat, and then the wood, slick with morning dew, slipped out from under her. Her body twisted in the air. She fell backward onto my lawn. The sound was not just a thud. Underneath it was a sharp crack, the kind that makes your stomach turn before your brain understands why. She screamed, high and breathless, and clutched her right arm. It was bent wrong. I could see that even from the window. She lay on the grass, gasping, tears running down her temples into her hair. Then her head turned. Mounted on the corner post of my fence was the security camera I had installed 3 weeks earlier. I had bought it because stray cats kept digging up my garden. A neighbor suggested motion-activated recording to identify which cat was responsible. The camera was mid-range, nothing special, but it had cloud backup, and I had linked it to my personal drive out of habit. I never thought about it after the first week, but Doris was staring at it now, at the small red light blinking in the corner of the lens. The pain in her face shifted into something else. Her mouth opened slightly. Her eyes went wide. She looked at that camera, the way a person looks at a witness they did not know was in the room. She did not scream again. She pushed herself up with her good arm, cradled the broken one against her chest, and limped toward my side gate. She did not try to climb back over. She just left, pulling the gate shut behind her with a soft click. I stood at the window for a long time after she was gone. I went to my computer and opened the camera software. The interface showed a grid of motion-triggered recordings sorted by date. I clicked on the first thumbnail, expecting to see footage of the cat I had been trying to catch. Instead, I saw Doris Whitmore climbing over my fence at 5:47 a.m. 17 days ago. I clicked the next one. Doris again, 5:52 a.m., 15 days ago. I kept clicking. 11 recordings, 11 separate mornings. The timestamps ranged from 5:30 to 6:30, always before the neighborhood woke up. In each one, she took something different. Tulip bulbs, rosemary from my herb box, garden shears I thought I had misplaced. And on day 12, she reached down beside my tomato plants and picked up a ceramic gnome that had been sitting there since I moved in. My mother gave me that gnome the year before she died. I watched Doris put it in her bag and climb back over the fence like it was nothing, like it belonged to her. I paused the video and stared at the frozen image of her holding it. That gnome cost $3 at a garage sale in 1987. It was worthless to anyone but me, and she took it anyway. My phone buzzed. 7:02 a.m. An email from the HOA management portal, the automated system that lets board members file complaints directly from their phones. The subject line read, "Urgent violation notice and hearing scheduled." I opened it. Resident Garrett Mitchell is accused of violating Section 4.7, causing bodily injury to a community visitor. A hearing is scheduled for Friday at 9 a.m. Interim penalty $2,500. The complaint had been submitted at 6:51 a.m., 34 minutes after she fell. While she was probably still sitting in the emergency room waiting for an X-ray, the system let her file it with one hand. The email claimed I had set a trap on my fence. It claimed she was an innocent visitor injured by my negligence. It demanded payment or threatened a lien on my home. I read it twice. Then I looked back at my screen, at the grid of 11 videos, at the frozen image of Doris Whitmore holding my mother's gnome. She had no idea this footage existed, and I decided, in that moment, that I would not be the one to tell her. The next 48 hours taught me exactly how much power one woman could hold over an entire neighborhood. I spent the morning after the incident researching Doris Whitmore, not because I wanted to, but because I had no choice. The HOA website told me everything I needed to know. President for 7 consecutive years, unopposed in the last 4 elections, chair of the Architectural Review Committee, the Fine Committee, and the Landscaping Approval Board. Every exterior modification, every penalty, every plant in every yard passed through her hands. Her husband, Ronald, was a retired real estate attorney who served as the HOA's unofficial legal advisor. He drafted the enforcement letters. He reviewed the liens. He made sure everything looked legitimate on paper. Together, they had built a closed system. Doris decided who violated the rules. Ronald made sure no one could fight back. I found 3 families who had sold their homes and left Cedarbrook Heights in the past 4 years, each after a dispute with the board. No lawsuits, no public complaints, just fines. Then liens, then moving trucks in the driveway. Silence and departure. That was how things worked here. I pulled up the CCNR document. 87 pages of dense legal language designed to confuse anyone without a law degree. Section 4.7, the one cited in my violation notice, was deliberately vague. It allowed fines for any action that caused harm to a community member, visitor, or guest. No definition of harm, no burden of proof. The maximum penalty was $500 per day until the issue was resolved. If they dragged this out for a month, I could owe $15,000 before I even had a chance to speak. I called the HOA management company twice. The first time, I reached a voicemail that was never returned. The second time, a representative told me all disputes had to go through the formal hearing process. Documentation would be provided at the hearing. The complainant's identity was confidential. When I asked how I was supposed to prepare a defense without knowing what I was accused of or who had accused me, she said that was not her department. Then she wished me a nice day and hung up. The system was not broken. It was working exactly as designed. The emergency board meeting happened on Thursday evening, less than 6 hours after a notice was posted to the HOA portal. I did not see the notice until it was already over. 4 board members attended, all personally appointed by Doris over the years. The meeting lasted 11 minutes. I obtained the minutes a week later. In that time, they voted to increase my penalty from $2,500 to $7,500 and authorized placing a lien on my property deed. The justification was that I had failed to respond to the initial notice within the required time frame. The required time frame was 48 hours. The original notice gave me until Friday. The meeting was held on Thursday. They moved the deadline backward, then punished me for missing it. Ronald Whitmore's signature was at the bottom of the lien authorization. Doris had recused herself from the vote, but remained present for the entire discussion. The lien meant I could not sell or refinance my home without first paying $7,500. It would appear on my credit report within 30 days. It would follow me until I paid or fought it in court. And court meant lawyers. And lawyers meant money I was not sure I could afford to spend. The next morning, an email went out to all 160 households in Cedarbrook Heights. It came from the HOA board account, but the writing style was unmistakably hers. Dear neighbors, for the safety of our community, we advise all residents to avoid contact with the property at 4712 Maple Lane until an ongoing investigation is resolved. A member of our community was seriously injured on this property due to alleged negligence. The board is taking all necessary steps to protect our neighborhood. My name was not in the email. It did not need to be. Everyone knew which house sat at that address. The replies came within hours. Neighbors I had never met expressed concern, outrage, and demands for more information. One woman asked if I was dangerous. Another suggested installing additional lighting near my property. A third said she would no longer let her children walk on my side of the street. I read every response, scrolling through them one by one, waiting for someone to ask what had actually happened. No one did. 47 replies, and not a single person wondered if there might be another side to the story. I closed my laptop and sat in the silence of my living room. 8 months I had lived here. 8 months of mowing my lawn, nodding to neighbors, keeping to myself. And in one email, I had become the threat they needed to unite against. That afternoon, a letter arrived by certified mail. The return address was a law office 1 town over, and I knew before I opened it what I would find. 2 pages of dense legal text, signed by Ronald Whitmore, attorney at law. His client, Doris Whitmore, was considering a civil lawsuit for negligence resulting in bodily harm. Estimated damages totaled $45,000, including medical expenses, lost income, and emotional distress. I had 14 days to respond through legal counsel or face formal litigation. I set the letter on my kitchen table and stared at it. The numbers arranged themselves in my head without effort. $7,500 in liens already on my deed, $45,000 in threatened damages, $500 per day if they decided to keep adding fines. My mortgage payment was $3,200 a month. I had savings, but not enough to survive a prolonged legal battle against people who had been doing this for 7 years. This was how the 3 families before me must have felt. This was the moment they decided it was easier to leave than to fight. I stood up and walked to my computer. The folder was still open on my desktop. 11 video files arranged by date. 11 timestamps. 11 recordings of Doris Whitmore climbing over my fence before dawn, taking things that did not belong to her, leaving the way she came. She had filed a complaint. She had rallied the neighborhood. She had threatened to sue me for $45,000. And she had done all of it without knowing that I had proof of every single visit. I clicked on the first video and watched her climb. The red recording light blinked in the corner of the frame. Steady and patient. She had made a mistake. She just did not know it yet. I made a decision that night. No public response. No arguments on neighborhood forums. No confrontation at her door. The instinct to defend myself was overwhelming. I wanted to post the videos immediately. Let everyone see what Doris Whitmore really was. But instinct is not strategy. If I released the footage now, she would spin it. She would claim the videos were edited. She would rally her allies before I could build a proper case. I needed to be smarter. I needed the evidence to speak for itself, but only when speaking would end the conversation permanently. So I started with the basics. Chain of custody. I downloaded all 11 video files to 2 separate external hard drives and uploaded encrypted copies to a cloud service using a password I had never used anywhere else. Then I called my sister in Oregon and asked her to hold one of the drives. She did not ask why. If anything happened to my equipment, the footage would survive. The next step was research. I spent 2 days reading California law and taking notes in a document I kept offline. Criminal trespass was a misdemeanor. Fines up to $1,000, up to 6 months in jail. Petty theft covered anything under $950. I calculated what Doris had taken. 20 tulip bulbs at $35 each. Garden shears. Herbs. The ceramic gnome was worth $3 in 1987, but priceless to me. Total material loss came to approximately $840, just under the threshold. But I kept reading. When theft was part of a pattern, the charges could escalate. And then I found what I was looking for. Burglary. Not just walking onto someone's property. Walking onto someone's property with the intent to steal. The distinction mattered. Trespass was an accident. Burglary was a plan. Every video showed Doris arriving with a bag and a trowel. She came prepared. That was not confusion. That was premeditation. The penalty was 2 to 6 years. I contacted 3 different offices. The non-emergency police line gave me the process for filing a report and told me to preserve the original files. The California Bureau of Real Estate, which oversees HOA operations. confirmed that boards were required to provide at least 48 hours notice for any meeting involving fines or liens. Doris had given 6. I searched for attorneys specializing in HOA disputes and found Nathaniel Cross, 20 minutes away, offering a free 30-minute consultation. I booked an appointment for Monday. His office was small, 2 rooms above a dry cleaner, but his walls were covered with framed case summaries and newspaper clippings about HOA lawsuits he had won. He watched the first 3 videos in silence. Then he paused on the 4th and pointed at the screen. "She's entering from the alley." I nodded. I had noticed it too. He explained why it mattered. If Doris had climbed from her own backyard, she could claim confusion about property lines. Weak, but possible. But she did not climb from her yard. She walked down the public alley, a route requiring her to leave her house, go around the block, and enter from a direction where no neighbor could see her. That was concealment. "This is premeditated," Cross said. "File a police report. Include all 11 videos. Request felony review." He leaned back. "People like her escalate. When she realizes you're not backing down, she'll try something else. Document everything." The law told me what Doris had done. Now I needed to prove she knew exactly what she was doing. I went through the footage again that night. Slower this time. I was looking for details I had missed. Anything that showed pattern and intent. I found it in the gloves. In every video, Doris wore the same pair of gardening gloves. Bright lime green with white trim. Distinctive, the kind sold at specialty garden stores. I paused on the clearest frame and saved it. Then I searched the neighborhood newsletter archives. Doris submitted photos regularly for the monthly Garden of the Month feature. 3 weeks ago, she had won. The photos showed her backyard in full bloom. Roses, hedges, and a row of black tulips along her back fence. My tulips. 20 Queen of Night bulbs. The exact strain I had ordered from Holland. She had planted stolen property in her own yard and submitted photos for a community award. I kept searching. The gnome appeared in a photo captioned, "My Quiet Corner." It sat beside a bird bath I had never seen, positioned as it had always been there. In the comments, someone asked where she got it. Doris replied that it had been in her family for years. I stared at those words for a long time. My mother gave me that gnome the year before she died. She bought it at a garage sale for $3. It meant nothing to anyone except me, and Doris had taken it, placed it in her garden, and lied about its origin to strangers on the internet. I saved every image. I cross-referenced dates with video timestamps. The theft on day 12 matched the photo upload 3 days later. The pattern was clear. She was not just stealing from me. She was displaying what she stole. She was proud of it. The green gloves in the videos matched the green gloves in her award-winning garden photos. The tulips she claimed to have grown were the tulips I watched her dig up at 5:47 a.m. The gnome, she said, belonged to her family, was sitting beside my tomato plants 2 weeks before it appeared in her birdbath corner. Every lie had a timestamp. Every theft had a photograph. I was organizing the files into a single folder when my phone buzzed. A new email from the HOA portal. Compliance inspection scheduled for 471 2 Maple Lane. Tuesday at 10 a.m. Please ensure access to the backyard for review of fence and landscaping regulations. I read it twice. She was trying to get inside my property. Legally this time. The timing was not a coincidence. She had seen me refuse to engage publicly. She had seen me ignore her threats. Now she was using the HOA's authority to gain access to my yard, to my fence, to the corner post where my camera was mounted. I did not know if she planned to inspect it, photograph it, or remove it entirely. But I knew one thing. She was not coming to check my landscaping. She was coming to find out how much I had seen. Tuesday morning, 10 a.m. I stood at my front window and watched 2 people walk up my driveway. One was a man in a polo shirt with the HOA Management Company logo embroidered on the chest. The other was a woman I did not recognize. Carrying a clipboard and a camera, they knocked. I opened the door but did not step outside. The man introduced himself as a compliance officer and said they were here to inspect my backyard fence and landscaping per the scheduled notice. I asked if they had written authorization from the homeowner, meaning me. He said the HOA had the right to inspect common areas and visible property features. I told him my backyard was not a common area. It was private property enclosed by a 6-foot fence. He glanced at the woman with the clipboard. She did not look up. I told them that under Davis Sterling Section 510, any inspection of private property required either my written consent or a court order. I had provided neither. The man started to argue. I closed the door. Through the window, I watched them stand on my porch for a full minute, speaking to each other in low voices. Then they left. But before they reached the sidewalk, the woman turned and looked directly at the corner of my fence, at my camera. She held the gaze for 3 seconds, then glanced toward Doris Whitmore's house 2 doors down. She nodded once, then they were gone. The attack started that afternoon. An anonymous post appeared on the neighborhood forum, titled, "Warning Dangerous Resident on Maple Lane." It claimed a new resident had installed surveillance cameras pointed at neighboring properties. It claimed an elderly woman had been seriously injured due to a trap on his fence. It urged parents to keep children away. Within 24 hours, there were 47 responses. Some demanded I be removed from the neighborhood. Others called me a predator. One woman said she had already warned her children never to walk past my house. Not a single person asked for evidence. Not a single person questioned the anonymous source. I read every comment. Then I closed the browser and did not open it again. The social isolation followed. Neighbors who had nodded at me for 8 months now looked away when I walked to my mailbox. The package drivers left my orders at the end of the driveway. I called a plumber to fix a leak under my kitchen sink. He confirmed the appointment, then canceled an hour before arrival. I called 2 more. Neither returned my messages. The neighborhood had made its decision. I was guilty. The details did not matter. Then the fines arrived. $350. Grass height violation. My lawn measured 3.2 inches. The maximum was 3 inches. I had exceeded it by 0.2 of an inch. $200. Improper trash receptacle placement. My garbage can sat 18 inches from the curb instead of 12. Both fines were added to my existing lien. Total now stood at $8,050. Both notices arrived on the same day. Both were signed by the fine committee chair, Doris Whitmore. The letter from my employer arrived on Friday. Human Resources had received a complaint from a concerned member of the public, alleging that I was under investigation for causing bodily harm and engaging in harassment. The complaint included HOA meeting minutes and the original violation notice. HR requested a meeting to discuss the matter. The email ended with a reminder that employees were expected to maintain conduct consistent with company values, both inside and outside the workplace. I sat in my kitchen and read it 3 times. My mortgage was $3,200 a month. My savings could cover 4 months without income. If I lost this job, I would lose the house. And if I lost the house, Doris Whitmore would win exactly the way she had won 3 times before. I stood up and walked to my computer. I needed to remember why I was still fighting. I opened the video folder. Day 12, 5:51 a.m. Doris climbed over the fence, carrying her green gardening gloves and her canvas bag. She walked to the corner beside my tomato plants. She knelt. She picked up the ceramic gnome my mother gave me. She looked at it for a moment, turning it over in her hands. Then she put it in her bag, stood up, and climbed back over the fence. No hesitation, no guilt, just a collection. I paused on the frame where she held the gnome. $3, 1987. My mother saw it at a garage sale and thought I would like it. She was right. I had kept it for nearly 40 years. And this woman took it because she could, because she believed no one would ever stop her. I closed the laptop. I was not going to sell my house. I was not going to run. She had taken enough. She would not take this. I went to bed at 11. At 2:47 a.m., my phone buzzed with a motion alert. I opened the app and watched the live feed. A figure in dark clothing stood at the corner of my fence, reaching for the camera mount. Hood pulled low, gloves on both hands. They tugged at the housing, trying to twist it free. The mount held. I had installed it with tamper-resistant screws 3 weeks ago, a precaution I almost skipped because it seemed excessive at the time. The figure pulled harder, stopped, looked directly into the lens. The hood shadowed most of the face, but the hands were fully visible in the motion-activated light, lime green with white trim. The same gloves from 11 previous videos. The same gloves from the Garden of the Month photos. She gave up after 4 minutes and disappeared into the alley the same way she always came. I saved the recording and added it to the folder. Video number 13. I lay in bed and stared at the ceiling. She had tried to destroy the evidence. She had walked to my property in the middle of the night, wearing the same gloves she always wore, and attempted to remove the only thing that could prove what she had done. She did not know about the cloud backup. She did not know about the encrypted copies or the hard drive in Oregon. She thought if the camera disappeared, the truth would disappear with it. That was her mistake. The camera was just hardware. The footage existed in places she would never find. And now I had one more video to add to the collection, one more timestamp, one more piece of proof that Doris Whitmore believed she was above consequences. She was wrong. The morning after the sabotage attempt, I filed a police report. Case number 2024, CF7831. I submitted all 13 videos through the department's online evidence portal, along with timestamps, descriptions, and screenshots of the green gloves matching those in the newsletter photos. The officer who reviewed my submission called that afternoon. He said the footage was clear and the pattern was concerning. He also said these cases took time, especially when the suspect was a long-term resident with no prior record. I thanked him and hung up. Time was something Doris had been counting on, but time works both ways. The longer this dragged on, the more evidence I collected, and I was nowhere near finished. I spent the next 2 days reaching out to former residents. Through a California Public Records Act request, I obtained a list of every home sale in Cedar Brook Heights over the past 5 years. Most were routine. 3 addresses stood out. 3 families who sold within 6 months of receiving their first HOA violation notice. I found 2 of them through public records. One had moved out of state and did not respond. The other lived 40 minutes away. His name was Martin Cole, 53 years old, former resident for 11 years, before selling 2 years ago. He agreed to meet at a coffee shop. He arrived early, sat in the corner booth, and did not smile when I introduced myself. Martin's story matched the pattern exactly. He had owned a copper weather vane shaped like a rooster. His grandfather made it by hand in 1952. One morning it was gone. No sign of forced entry, no damage to the roof, just gone. 2 weeks later, he drove past Doris Whitmore's house and saw it on her roof. When he knocked on her door and asked about it, she smiled and said it had been in her family for decades. When he insisted it was his, she threatened to call the police for harassment. When he brought it up at the HOA meeting, 4 board members said he was mistaken. The following month, he received his first violation notice, then another, then a lien. 8 months later, his wife could not take it anymore. They sold at a loss and never came back. I asked if he would provide a written statement. He said yes without hesitation. "I've been waiting 2 years for someone to fight back," he said. "Make her pay for all of us." I drove home with his signed statement in my passenger seat. One more piece of the pattern. That week, my attorney, Nathaniel Cross, sent a formal cease and desist letter to Doris regarding the defamatory forum posts. The letter outlined the false statements, cited California defamation statutes, and demanded removal within 7 days. Her response came within 24 hours. Not to Cross, to the entire neighborhood. A new post appeared under her real name. "It has come to my attention that certain individuals are using lawyers to intimidate elderly women who speak up for community safety. This is a classic tactic of abusers. I will not be silenced." 89 reactions, 62 supportive comments, no mention of my name, but everyone knew. Cross told me to document it and wait. "She's digging her own grave," he said. "Every post strengthens our case." The documents from the HOA management company arrived on Friday. I had requested all meeting minutes, financial reports, and violation records from the past 3 years. The packet was over 200 pages. I started with the minutes from the emergency session that placed the lien on my property. According to the CCNR, any vote on fines or liens required a quorum of 5 board members. The minutes listed 3 attendees. 3, not 5. The vote was invalid. The lien was illegal. I kept reading. Buried in the financial reports was an email thread between Doris and the HOA treasurer. Subject line, "Mitchell situation." First message, from Doris. "Just push it through. He doesn't know the rules. By the time he figures it out, he'll be too tired to fight. We settle when he sells." Treasurer's reply, "Done." 1 word. That was all it took. I read those words 3 times. She knew the meeting was improper. She knew the lien was illegal. She did it anyway because she believed I would give up like everyone else. I printed the email and added it to my evidence folder. The numbers arranged themselves in my head. $8,050 in fraudulent liens, $45,000 in threatened damages for an injury she caused by trespassing, $1,847 in stolen property across 13 videos, 3 attendees when 5 were required, 1 email proving intent, 1 witness with a parallel story. If I lost, I would lose everything. If I won, she would face criminal charges, civil liability, and removal from the position she had held for 7 years. I called Nathaniel Cross and told him what I had found. Silence on the line for 5 seconds. Then he said, "This changes everything. She didn't just abuse her power. She committed fraud, and she put it in writing." I asked about the next step. He explained that under Davis-Sterling Section 5510, if 5% of homeowners signed a petition requesting a special meeting, the board was legally required to hold one within 35 days. The meeting would allow any homeowner to present concerns to the full community. I could show the videos. I could present the documents. I could let every resident in Cedar Brook Heights see exactly what their HOA president had been doing. 5% of 160 households meant 8 signatures. I asked Cross if he thought I could get them. He paused. "After what's in these documents," he said, "you might get more than you need." I hung up and sat at my desk, looking at the folder on my screen. 13 videos, 200 pages of records, 1 signed witness statement, 1 email that proved Doris knew exactly what she was doing when she placed an illegal lien on my home. She had spent 7 years building a system designed to crush anyone who challenged her. She had driven out 3 families. She had stolen from neighbors and displayed the evidence in her own yard. She had tried to destroy my career, my reputation, and my home, and she had done all of it believing no one would ever hold her accountable. I opened a new document and began drafting the petition. 8 signatures, 35 days. It was time to let the neighborhood see who Doris Whitmore really was. I spent the weekend organizing everything into a single folder. 13 videos sorted by date, 200 pages of HOA documents with critical sections highlighted, screenshots of the newsletter photos showing my stolen property in Doris's yard, Martin Cole's signed statement. The fraudulent email proves intent. Nathaniel Cross reviewed the materials and called it the most comprehensive HOA abuse case he had seen in 15 years. But something still bothered me about the footage from the day Doris fell. I had watched it dozens of times, always focused on the fall itself, the crack of her arm, the panic when she saw the camera. I had never looked closely at what came before. That Sunday night, I opened the video again and watched frame by frame. She climbed over the fence at 6:17 a.m., carrying her usual canvas bag and trowel. Standard routine, but this time I noticed her dress. Deep pockets on both sides. As she knelt to dig, something shifted in her right pocket. A glint of metal. I paused and zoomed in. The image was grainy but clear enough. A key on a small tag. 4 digits written on the tag. 4712. My address. Doris Whitmore had a copy of my house key. I sat back and let that sink in. The back door of my house used the original lock from 1986. No deadbolt. I had meant to upgrade it, but never did. If she had a key, she could have entered any time I was away. I opened my indoor camera app, the one I installed to watch my cat during work trips. Same cloud service. Same 30-day retention. I had never checked it for anything except cat footage. I scrolled through the motion history. Day 15, 3:27 p.m. I was at a doctor's appointment that afternoon. Gone for 2 hours. The camera activated. The footage showed my living room from the corner near the bookshelf. 10 seconds of stillness. Then the back door opened. Doris Whitmore stepped inside. She stood in my living room and looked around slowly, memorizing the layout. Then she walked to my desk. She opened the top drawer. She rifled through papers, pulling out documents one by one. I watched her read my mortgage statement. I watched her flip through tax returns. I watched her photograph something with her phone, the screen lighting up her face. 11 minutes inside my house. Then she put everything back, closed the drawer, and left through the back door. She locked it behind her with a key she should never have had. I called Nathaniel Cross at 9 p.m. on a Sunday. He answered on the second ring. I told him what I found. Long silence. Then he said, "That's not trespass anymore. That's burglary, entering a structure with the intent to commit theft or any felony. It doesn't matter if she took anything. The intent is enough. That's a felony charge. 2 to 6 years in state prison." I asked what we should do. He told me to add the footage to the police report immediately and request that the investigation be upgraded. He also told me it was time to send the petition. "You have everything you need," he said. "More than enough. Let the neighborhood see it." I drafted the email that night using the HOA resident directory from the management company documents. 160 households. Simple message requesting a special meeting under Davis Sterling open meeting requirements. I stated that I had evidence of serious misconduct by the current board president, including criminal trespass, theft, fraud, and unauthorized entry into a private residence. I did not attach the videos or documents. Evidence would be presented at the meeting if the petition reached the required signatures. Sent at 11:14 p.m. By noon the next day, 14 signatures. By Wednesday, 23. Martin Cole drove back to sign in person. 3 former residents sent notarized statements. The threshold was 8. I had nearly triple. The meeting was scheduled for Saturday at the community center. Doris found out on Thursday. I do not know who told her, but I saw the result. An emergency board meeting was called with less than 4 hours' notice. 5 members are present this time. Single agenda item: community safety concerns regarding the upcoming special meeting. I obtained the minutes the next day. The board voted 4-1 to ban me from the community center, effective immediately. The stated reason was that my presence posed a risk to residents based on ongoing allegations. The one dissenting vote came from Patricia Vance, who noted that banning the petitioner from attending the meeting he requested might violate open meeting requirements. Her objection was recorded and overruled. I received the ban notice on Friday morning, less than 24 hours before the meeting. Doris thought she had won. If I could not enter the room, I could not present evidence. If I could not present evidence, the neighborhood would never know. She was wrong. I called Nathaniel Cross. He reminded me that while I was banned, he was not. As my legal representative, he had the right to attend any HOA meeting and speak on my behalf. He had the right to present evidence relevant to homeowner concerns, including videos, including documents, including footage of the HOA president inside my house without permission, and photographing my private financial records. Friday evening, I met Cross in his office above the dry cleaner. I handed him a flash drive, 13 outdoor videos, 1 indoor recording, 200 pages of documents, 23 petition signatures, Martin Cole's statement, the fraudulent email, screenshots of stolen property displayed in Doris's yard, everything I had collected over 6 weeks of silence and preparation. He weighed the drive in his hand like it was something heavier than plastic and circuitry. "She has no idea what's coming," he said. I told him that was the point. He nodded once and put the drive in his briefcase. Tomorrow, 73 residents would gather in the community center expecting a routine dispute. Tomorrow, Nathaniel Cross would walk into that room carrying 6 weeks of evidence that Doris Whitmore had spent 7 years believing would never exist. I would be standing outside, but my footage would be inside, and that was all that mattered. I went home and did not sleep. I sat at my kitchen table and waited for the morning. The ceramic gnome was still in Doris's garden. My tulips were still blooming in her yard, but not for much longer. In 12 hours, everyone in Cedarbrook Heights would see exactly who their HOA president really was, and there would be nothing she could do to stop it. Saturday morning, 9 a.m., I stood across the street from the Cedarbrook Heights Community Center and watched 73 residents file through the front doors. The parking lot was full. People had brought lawn chairs. Patricia Vance, the board member who voted against banning me, sent a text that morning. "Standing room only. Everyone wants to see what you found." I could not go inside. 2 board members were stationed at the entrance, checking names against a list, but I could see the windows. I could see the projector screen through the glass, and I could see Nathaniel Cross walk through the front door at 8:55, carrying a laptop bag and the flash drive I had given him the night before. The meeting started at 9:15. First 10 minutes were procedural. Approval of minutes. Treasurer's report. People were restless. They had not come for this. At 9:26, Cross stood up and connected his laptop to the projector. The screen flickered. The first video began to play. I could not see the footage from where I stood, but I could see the faces. Confusion, recognition, shock. 73 people watched in silence as Doris Whitmore climbed over my fence at 5:47 a.m., dug up my tulips, and disappeared into the alley. Cross played the next 10 videos in rapid succession. Same pattern each time. Doris arrived before dawn. Doris is taking something. Doris leaving. By the 5th video, heads were turning toward the front row where she sat. By the 10th, no one was looking at the screen anymore. They were looking at her. Then, Cross played video 12. The fall. The crack of her arm. The moment she looked up and saw the camera. Video 13 followed immediately to 47 a.m. A figure in dark clothing is reaching for my camera mount. Lime green gloves are visible in the motion-activated light. 4 minutes of attempted sabotage before she retreated into the alley. And then the final video, the one from inside my house. 73 people watched Doris Whitmore open my back door with a key she had no right to possess. They watched her stand in my living room. They watched her walk to my desk, open my drawer, and photograph my private financial documents. 11 minutes of footage that turned trespass into burglary. When it ended, Cross let the silence hold for 10 seconds. No one moved. He began presenting the documents. Emergency meeting minutes showing 3 attendees when 5 were required. The email from Doris to the treasurer displayed on screen for everyone to read. Just push it through. He doesn't know the rules. By the time he figures it out, he'll be too tired to fight. Then the newsletter photos. My tulips in Doris's garden, captioned as her own. My mother's gnome beside her bird bath, claimed as a family heirloom. Timestamps that matched the theft footage within days. Martin Cole stood up without being called. He walked to the front and told his story. The copper weather vane that his grandfather made in 1952. The morning it disappeared. The day he saw it on Doris's roof. The months of fines that followed. The house he sold at a loss. When he finished, 3 other hands went up. A garden statue. Antique wind chimes. A decorative fountain. Doris had been doing this for years. She stood up. The room went silent. Her voice carried. High and sharp. This is a setup. Those videos are edited. That man is dangerous. Cross responded calmly. The footage had been submitted to police. Case number 2024, CEF 7831. Metadata verified. Timestamps authentic. She cut him off. I don't care about metadata. I am the president of this HOA. I have protected this neighborhood for 7 years. Cross said nothing. He clicked to the next image. A freeze frame from the indoor video showing Doris holding my mortgage statement. Silence. Her composure cracked. Face flushed red. Hands clenched. Those things deserve to be in my yard, she shouted. The room froze. His garden was a mess. He didn't even take care of them properly. I made them beautiful. I gave them a home they deserved. 73 witnesses. Every word is recorded by the community center's security system. She had just confessed to theft in front of the entire neighborhood. The room erupted. Patricia Vance called for order. When the noise died, she called for a motion to remove Doris Whitmore from the board. The vote was 61-12. 7 years of power ended in 11 seconds. I watched Doris walk out of the community center at 10:47 a.m. Ronald followed 3 steps behind, head down, saying nothing. The $45,000 lawsuit had been withdrawn that morning. The $8,050 lien would be voided within 30 days. Cross had already filed a complaint with the state bar regarding Ronald's role in the fraudulent lien. Doris crossed the parking lot. Then she saw me. She stopped, walked toward me until she was close enough that I could see the vein pulsing in her temple. You think you've won, she said. You'll never be safe in this neighborhood. I'll make sure of it. I did not respond. I did not need to. Behind her, 73 residents were filing out of the community center. Every single one of them was looking at her. The threat hung in the air between us for 3 seconds. Then she turned and walked to her car. Ronald opened the passenger door for her, without a word. They drove away, and I watched until the car turned the corner and disappeared. Cross came out 5 minutes later. He handed me back the flash drive and said 4 words. It's done. She's finished. I put the drive in my pocket and looked at the community center. People were still standing in small groups, talking, shaking their heads, processing what they had seen. A woman I did not recognize approached me. She said her name was Ellen, and she had lived in Cedarbrook Heights for 14 years. I'm sorry, she said. I believed the posts about you. I should have asked. I told her it was fine. She shook her head. No, it wasn't. But thank you for not giving up. She walked away. 3 more people approached over the next 10 minutes. Same message, same apology. I accepted each one and said nothing else. The neighborhood had made its judgment. Doris Whitmore was no longer the protector of Cedarbrook Heights. She was the woman who stole from her neighbors and lied about it for 7 years. And everyone knew. 2 weeks after the meeting, the full weight of consequences landed on Doris Whitmore. The police upgraded their investigation based on the indoor footage. She was charged with 1 count of felony burglary, 11 counts of misdemeanor trespass, and 1 count of petty theft. Total bail was set at $25,000. She hired a criminal defense attorney and pleaded not guilty, but the evidence was overwhelming. 13 videos, 73 witnesses to her confession, a paper trail of fraud. Ronald Whitmore resigned from his unofficial role as HOA legal advisor the same week. The state bar opened a preliminary inquiry into his involvement with the fraudulent lien. Their house went up for sale 3 days later. After 7 years of ruling Cedarbrook Heights, Doris and Ronald were leaving. Nathaniel Cross called me with an update. He said I had a strong case for civil litigation, trespass, theft, defamation, intentional infliction of emotional distress. He estimated I could recover between $150,000 and $200,000 in damages. She destroyed your reputation, he said. She tried to take your job. She put an illegal lien on your home. A jury would not be kind to her. I told him I needed to think about it. He said to take my time. I hung up and sat at my kitchen table for a long time, looking at the folder on my laptop. 13 videos, 200 pages of documents. 6 weeks of my life spent building a case against a woman who had tried to ruin me. I had won. The question was what winning meant. I called Cross back the next morning and told him I was not filing a civil suit. He was quiet for a moment. "You're sure?" he asked. I said I was. Doris was 56 years old. She was facing felony charges. She was losing her home, her position, and her reputation. Her husband might lose his law license. I had already taken back everything she tried to take from me. My name was cleared. The lien was void. My job was secure. Filing a lawsuit would not give me justice. It would give me money earned from someone else's destruction. That was not why I fought. I fought because she crossed my fence. I fought because she took things that were not hers. I fought because she thought no one would ever stop her. Stopping her was enough. I wrote a victim impact statement for the district attorney's office. I did not ask for leniency, but I did not ask for maximum punishment either. I wrote that my goal was accountability, not revenge. I wrote that I believed probation with supervision would serve the community better than incarceration. I wrote that Doris Whitmore needed to understand that her actions had consequences, but that those consequences did not need to include a prison cell. The DA's office acknowledged receipt. They said my statement would be considered during plea negotiations. I did not know if it would make a difference. I only knew that I could live with what I had written. Doris sent one final message before she left the neighborhood. Not to me directly, to the HOA mailing list. "It has come to my attention that some residents feel I have been treated unfairly. I want to assure everyone that the truth will come out in court. Garrett Mitchell may have fooled this community, but he will not fool a judge." 81 recipients, 0 replies. The email was forwarded to me by 3 different neighbors. I saved it to my evidence folder, but did not respond. Some people never learn. Some people cannot admit they were wrong, even when the proof is undeniable. Doris Whitmore was one of those people. I felt something close to pity. Then I closed my laptop and let it go. If you've ever dealt with a neighbor who thought the rules didn't apply to them, you know how this feels. The frustration, the helplessness, the moment you realize no one is coming to save you except yourself. That's what Karma Fence is all about. Real stories of everyday people who stood up, gathered evidence, and let the truth do the fighting. Like and subscribe so you don't miss the satisfying ending. Comment below where you're watching from.